This is your host, Carl Opedal. Okay, anyway, welcome everybody. Here we are, and of course, for over half of the people who are attending, for over half of us, the reason we're here is that we originally were going to be all together in Alexandria, Virginia on April 23rd for Design Day at the USPTO. We were all going to be together for Design Day, and of course, unfortunately, events overtook other events, and Design Day got canceled. And the practical consequence was that Design Day was not going to happen. And so what I did was I was going to be one of the presenters. I was going to be presenting on this very topic, the digital access system and its most recent developments as they relate to the world of industrial designs, design patents in the United States. And so I decided I'd go ahead and do that presentation as a live webinar, which is why we're here today. So welcome everybody. Our scheduled time is 90 minutes, an hour and a half. The prepared materials are likely to last just over an hour, and then the situation we have is that if all goes well, we will have time for questions and answers as well. My presentation style is to encourage people to ask questions as they come up. And don't feel like you have to save questions to the end. So go ahead and ask questions. Standard disclaimer, I am not your lawyer and you are not my client. We're here for instructional purposes for class. The starting point to all this was in Paris. The movie Casablanca, which I consider to be one of the best movies ever made, finishes with, it's actually a man talking to a woman and saying, we'll always have Paris. And it's Humphrey Bogart talking to Ingrid Bergman. And we'll always have Paris, he says. And in the world of intellectual property, we'll always have Paris. In 1883, a bunch of dead white males came up with the Paris Convention for the Protection of Industrial Property. And the goal was to fix a bunch of things that had by then gone wrong. Many treaties exist to fix things that people realized were going the wrong way. And one thing that was going the wrong way by 1883 was that patent offices and offices for protecting designs and offices for protecting trademarks were treating citizens of other countries worse than they treated their own citizens. And this treaty came into existence principally to make it so that countries would be shamed into treating citizens of other countries as well as they treat their own citizens. A theme that resonates 140 years later, frankly. The idea that every country ought to treat the citizens of everybody in all other countries as well as they treat their own citizens. And the treaty went on to say, for example, that if you filed an application in a first country and then later filed an application in a second country, you could claim priority in the second country, and the second office would treat the application as if it had been treated on the same day that that application was filed in the first country. And one of the wrongs that was being righted, one of the abuses that was being addressed, was that it should not require any authentication. You'll see in the middle of the page there, it shall not require any authentication. And what's happened was that offices were deciding that this was a profit center, and one of the ways that they were going to take advantage of foreigners was to charge foreigners a lot of money and require that things be authenticated in the embassy in that foreign country for $600 or something. And this treaty said, no, you're not allowed to require authentication. All that you're allowed to require that it be certified by the first office. If they certify it as correct, then it's not going to be necessary that there be authentication by an embassy. There are a bunch of other things the Paris Convention does. The Paris Convention requires that if there are annuities or maintenance fees, that there be a grace period of no less than 6 months to hand in your money late if you missed your time period for your annuity or maintenance fee. Well, the main thing here that brings us together for this webinar is this particular provision, which is in Article 4 of the Paris Convention, namely, if any country belongs to this treaty, they are obligated to make possible Um, they're obligated to make priority claims possible. You're not allowed to say no if somebody wants to present a priority claim, and if you want to claim priority, the patent office is not allowed to say no, or the design office or the trademark office, as long as both countries involved belong to this treaty, and as long as you satisfy other conditions, which we will talk about a little bit. What are the conditions? Well, one of the conditions is that the second office, the so-called Office of Second Filing, is permitted, if they want to require that you proffer a certified copy which shows the date on which the first application was filed. This is sort of common sense, right? If somebody goes to a country and says, you have to treat me as if I filed this thing 6 months ago or a year ago, common sense tells you people might just make this stuff up. People might not tell the truth. And one of the ways to keep everybody honest is to say, well, you got to come up with a certified copy so that if anybody ever wondered, they could look at the certified copy and they could see with their own eyes when it was filed, and they could see the content of the filing. So it's kind of common sense. Having said all this, you'll see in the slide that's in front of us, what I've highlighted is the word may. Offices may require. They don't have to. If they don't feel like it, they can just trust you. They can just say, send us a photocopy, run it through the copier and just send us a copy. Or just tell us. Maybe we'll take you at your word. And in the world of trademarks, there are a lot of trademark offices that are willing to essentially take you at your word. I think on the grounds that most trademark filings are a matter of public record, and that if somebody started making stuff up, it would be found out. It would be easy enough for somebody sitting at home in their pajamas to click around in the website of the other trademark office, the Office of First Filing, and they could find out if somebody was making stuff up. But in the world of patents, for example, it's kind of a high stakes thing. You really would not want people to be able to get away with making stuff up. And so it's understandable that most patent offices do, in fact, require that a certified copy be provided. And in the world of designs, some design offices require a certified copy. That's why we are here today, because some offices of second filing choose to say, we will require that a certified copy be provided. Okay, so that's kind of our setup. And now let's start talking through how this goes. Well, one thing is that the Paris Convention, I will tell you, when I was first in practice, I had never actually read Article 4 of the Paris Convention or any of the rest of it. And probably a decade went by before I actually did the pesky business of reading it to see what it said, and it's something everybody should do. Everybody should read at least Article 4 of the Paris Convention. And the first Director General of the organization that is now known as WIPO, that was once known as BURPE, the Bureau of Intellectual Property. In the old days, it was called the Regional Bureau of Intellectual Property, and now it's called WIPO. But the first Director General was a fellow named Bodenhausen, and he chose to write a book all about the Paris Convention. And he went through the Paris Convention from the top to the bottom, and he wrote everything he could think of that a person might want to know about the Paris Convention. It's a really good book. Now, I will admit it's a bit dry in parts. You might put it down and pick it up again later, after you have gotten a bit of coffee or something. But it's an important book, and everybody should have it on their bookshelf. Everybody should read at least the part of his book that's talking about Article 4 of Paris. It's out of print. WIPO published it, and then they let it go out of print. But they've published a PDF of it. You can get a PDF of it. You could print it on your laser printer, or if you count up how much money you'd have to spend for the toner in your printer to print it, you can actually buy a printed copy cheaper on the website of our firm. We sell it for just the cost of printing, and it's a nice, clean, clear printed copy. But you can print it yourself for free. But it's something that everyone should have on their bookshelf. Okay, Article 4 of Paris. In broad strokes, what are we talking about? You file in what we will call an Office of First Filing, And within 6 months, if you're talking about design, you file in an office of second filing. And if all goes well, if you satisfy various conditions and requirements, the second application will be able to claim priority from the first application. That's what we're talking about. That's why we've already been in this webinar for 11 minutes, and that's why we're going to be here for another hour and 39 minutes. Because you can do this thing that's on the screen here. Of course, Article 4 of Paris also defines priority periods for two other kinds of intellectual property besides designs. Most of you know this. Trademarks, also 6 months, and of course, utility patent coverage, 12 months. But here today, we're mostly talking about designs, and 6 months is our time period. Okay. What does this mean, by the way? This means that anytime you file any application that has a chance of being a priority document for a client of yours, that later the client might want to try to get a patent in another country after the country that you just filed an application in, you better darn well docket the heck out of that. Docket the 6 months. Make sure the client doesn't snooze through and somehow not pay attention to the idea that maybe they were going to want to get design protection in the second country. You need to remind them about it. And why are we writing that email or that letter? Well, 10% of the reason is to tell them what I just said. 90% of it is to cover your behind. 90% of it is so that there's a very clear record that you told them. So that down the line, if the client ever said, oh, you know, how come you never told me about the 6 months? You can say, I did tell you about the 6 months. See, here's this email. And they say, I never got that email. And you can say, well, you replied to it. You then asked me about it. Well, you must have gotten the email. Anyway, the 6 months. And if you had filed anything that could be a priority application for trademark purposes, you'd want to docket the same 6 months to remind the client about 6 months for a trademark foreign filing, and of course 12 months for utility patent coverage. Okay, patent law treaty. The United States joined the Patent Law Treaty in December of 2013, and some countries also belong to the Patent Law Treaty. And the countries that do, well, some of them literally join the Patent Law Treaty, and there are other countries that, even if they don't join it, they choose to make their own law conform to the Patent Law Treaty. They choose to make it so that you get the same benefits you would get if the country had joined the Patent Law Treaty. And one of the benefits you get if a country belongs to the Patent Law Treaty is that no matter how badly you screw something up that would lead to irrevocable loss of rights, you always have 2 months to fix whatever it is that you screwed up. So for example, you let something go abandoned, you got 2 months to revive, minimum. You fail to respond in office action, 2 months at least to respond or to revive or whatever. Back when this happened, well, it used to be if you got a restriction requirement in a patent case in the USPTO, you got 1 month to respond to that restriction requirement. Well, all of a sudden, because our country joined the PLT, 2 months became the time for responding to restriction requirements. You wonder why it is that it changed from 1 month to 2? This was why. Well, in particular, PLT is the reason why you can do what this slide says. Namely, if somebody filed a design application in a foreign country, then suppose you were going to file in the USPTO claiming priority from that foreign design application. When do you got to do it? You got to do it within 6 months. What are the consequences if you snooze through it and fail to file within the 6 months? Well, the fact is the US belongs to the PLT, which means you might be able to restore the right of priority under certain circumstances, and you might, if you manage to discover the mistake before 8 months had come and gone, you might be able to file that US case and restore the priority. We're not going to go into that in great detail today. That's not the main purpose of today's webinar, but I'm mentioning it just to be complete, just so that you will keep in mind that if a client ever comes to you and says, I already filed in such and such a foreign country on my design, and more than 6 months went by, is it too late to file in the US and claim priority? This slide will remind you that the answer might be, maybe you could still file in the US if 8 months has not yet come and gone. That's the purpose of this slide, just to sensitize you to that possibility that you might be able to salvage something. Same thing an extra 2 months for utility coverage. That is to say, if somebody missed the 12 months, but the screw up was discovered before 14 months had come and gone, you might be able to do what is called restoration of the right of priority within the 14 months. So that's what this slide is talking about. And again, this is not central to today's webinar. I'm just mentioning it because it relates to priority claims. Now, if the U.S. is the Office of Second Filing, that is to say, if what we are contemplating is filing in the U.S. and claiming priority from a filing that happened previously in some place outside of the U.S., here are the sections that matter. For some of you folks, you have this memorized, section 119A through D of 35 U.S. Code. This section of the CFR and this part of the MPEP. When do you have to accomplish the stuff that is set forth here? Presenting the priority claim and coughing up the certified copy. When do you have to do it? And the answer is for utility cases, we'll talk about this in more detail in the next couple of slides. For utility cases, you got to do it within the 4 and 16 time period. For design cases, there is no 4 and 16 limit. As long as you manage to somehow get it accomplished before the design patent issued, it would be just barely soon enough, and we'll talk about that later. A question has just come in. Somebody asks, suppose you're going to use restoration of the right of priority to solve the problem of having missed your 6 months, but you managed to discover the screw up before 8 months had come and gone. Do both the Office of First Filing and the Office of Second Filing have to be members of the Patent Law Treaty for this to work? And the good news is consult competent counsel in the Office of Second Filing, but the general answer all around the world is that in the Office of Second Filing, all that has to happen is that the Office of Second Filing belongs to the Patent Law Treaty or has its domestic law compliant with the Patent Law Treaty. Even if the Office of First Filing did not belong to that treaty, that would normally not be a problem. It's enough if the Office of Second Filing belongs to the PLT or has caused its law to be compliant with the Patent Law Treaty. But consult competent counsel in the country of interest to make sure about that. Okay, depositing offices. I'm kind of a slide early here. Well, all right. Depositing offices for designs. Yeah, this is curious. These slides are not quite in the sequence I had in mind here. Something's odd. Oh, here we go. Well, all right. I'm going to jump ahead to slide 20. I'm going to jump ahead to slide 20 because this is really what I wanted to talk about next. What's the legacy approach? For the old timers who are with us on this list, and I'm looking down the list of people who are with us here today, we have about 153 attendees. And of our 153 attendees, I see some names of people who have gray hair just like me. People have been practicing for some time. By the way, we have attendees with us from every continent except Antarctica. Welcome, people from every continent except Antarctica. But anyway, for the old timers among us, there used to not be computers, right? I mean, in the old days, when you filed a design application in a first country and a second country, it was done with stone tablets and chisels. The youngsters who are with us on today's webinar, you have no idea how easy you have it, you youngsters. Us old timers, we know stone tablets and chisels is how it used to be done. One guy says his hair is only partially gray. Thank you, thank you. Yeah, make me feel good. Anyway, yeah, in the old days, I'm exaggerating, it actually wasn't stone tablets and chisels, but what it was physical certified copies. And so what would happen? Well, if you were the instructing counsel, if you were the design practitioner in Europe, let's say, what would happen? Well, you would be sending instructions, say, to U.S. counsel. So you'd have to order up a physical certified copy from your design office in Europe. The physical certified copy would arrive in your office. Meanwhile, you would have to have set a docket to remind yourself, make darn sure we send it to foreign counsel in the United States. So then you send it to the counsel in the United States, and then you have to set a docket to check to make sure that DHL says they delivered it to U.S. counsel, right? Then once DHL has told you it was delivered to U.S. counsel, you need to set and clear a docket making sure that U.S. counsel admits that, yes, they received the physical certified copy. Then if you're European counsel, you can't just trust that U.S. counsel is going to do a good job of delivering that thing to the U.S. Patent Office. You need to docket and check and make sure that you later get some sort of independent confirmation that the U.S. Patent Office really did receive the certified copy. We're talking about European counsel having to set and clear a minimum of 5 dockets, okay? Minimum of 5 dockets. That's nowhere near the entire docket setting and clearing, right? Suppose you're the U.S. counsel in the Office of Second Filing. What happened? Well, your instructions came in from foreign counsel. Please file a design application in the U.S. Patent Office, in which case the first thing you had to do was set a docket to check and make sure that your foreign counsel sends you the physical certified copy. Then they send you a note that says, well, we sent it to you, and here's the DHL tracking number. So now you have to set up a notification to make sure that DHL actually delivers it to you, and then set a docket and make sure the physical certified copy shows up. Then when it shows up, then you have to send it. Well, you have to dock it to make sure that we don't forget to send it to the USPTO. Then we put it into an envelope, we send it to the USPTO. We then have to dock it and make sure that the Postal Service says that it delivered it to the USPTO. Then when the USPTO says that it was sent, what was one of the things that was in the envelope? It was a return postcard. We have to dock it and check to make sure that the return postcard comes back saying that it was delivered. Then are we done? No, of course not. Then we have to dock it to check to make sure that we can see it in IFW. Can we relax? No, of course not. We then have to dock it to check to make sure that the examiner in the USPTO either checks box 4 or box 12, in which the examiner says, I admit it, yeah, you did provide the certified copy. Only then can you relax. If you miss any of these dockets, down the line, you're going to have a patent that could be destroyed at litigation time if it turns out that that priority claim had not been perfected. Why? Because there's no clear record that the certified copy ever got into the U.S. case. We're talking setting and clearing perhaps 7 dockets. So between foreign counsel, 5 dockets, U.S. counsel, 7 dockets, all told perhaps 12 dockets being set and cleared, and money being spent, a fee being paid to get the physical certified copy, money being paid to DHL to send the courier package, domestic delivery fee to send the Postal Service package to the USPTO. In my office, in my own firm, we estimate internally, that setting and clearing any docket imposes an internal cost to our firm of $50. Labor cost, time of our employees, interrupting them from other tasks they would have been doing. This is the legacy approach. This is why WIPO created the DAS system. A couple of questions came in. One person said, as part of your process, do you verify that the IFW reflects every page of the certified copy? And what he's getting at, of course, is if you send a physical certified copy to the USPTO, what happens to the physical certified copy? Well, it goes to a room where some USPTO employee takes a drill and punches out the brass grommet, and then runs it through a scanner and then scans the pages and scans them into IFW, right? Well, what if it was double-sided? And what if the person doing the scanning didn't notice it was double-sided and all that got in was the odd-numbered pages? What if all the even-numbered pages got lost because they didn't scan it double-sided? Or what if 2 pages stuck together? This is one of the things that this guy is thinking of, and he's probably had it happen. 2 pages stick together going through the scanner. Does that mean you haven't really perfected your priority claim because page 5 and 6 stuck together going through the scanner at the patent office? Then he asks, well, but if the examiner checks box number 4, does that mean that it doesn't matter if 2 pages stuck together? So having reminded ourselves of the legacy approach, we're now going to talk about DAS. Now, some of you have used DAS, and almost all of you, hopefully, did the DAS quiz. Okay, let's see here. Almost all of you did the DAS quiz, so you already have successfully gotten a WIPO user ID and password, and you have established a workbench in the DAS system, and hopefully almost all of you successfully added a particular US provisional patent application to your workbench in DAS and set up tracking so that you would know if any patent office around the world retrieved that application from the DAS system. If so, then you already know at least a little bit of what I'm about to explain here, and that is that offices around the world choose to join the DAS system, and if they do, they might be a depositing office. That is to say, they might make it so that if you file a design application in their patent office or design protection office, that they will make the design application available electronically to the DAS system. Which offices now are trendy, modern, and up to date? Which ones belong to this club? Australia, Canada, Chile, China, Spain. GE is Georgia, India, Japan, South Korea, Norway, and the US Patent Office all belong. The most recent one that joined is Norway. Norway is the trifecta. They achieved the highest level of trendiness, modernness, and up-to-dateness on the day they joined, which was January 1 of this year. They made every kind of protection that they have available to the DAS system: trademarks, utility models, patents, and industrial designs. What is absent from this list? Well, we all know about the ID5. The ID5, the Industrial Designs 5, the 5 biggest offices for protection of industrial designs, which is US, EU IPO, the European Union Intellectual Property Office, Japan, Korea, and China. Those 5 offices between them account for something like 90% of all the design protection activity that takes place. You would think they would all belong to this system. And I, with some regret, have to tell you that the European Union Intellectual Property Office does not yet belong. Does not yet belong. The US does. Korea, Japan, China, they all belong to the DAS system for purposes of depositing priority applications into the DAS system. But no, not the European Union Intellectual Property Office, which is the office formerly known as OHIM, OHIM. One of our commenters says Norway was taken by surprise by the WIPO notification, and they are in fact not yet ready to prepare or receive electronic copies in the DAS system. Somebody says here Netherlands joined as of July last year, but I don't think they did for designs. Maybe they did. They joined only for patents. They did not join for designs. Okay. Thank you, by the way, for those questions and comments. That's very helpful to have comments from people. And it reminds me that people have not all fallen asleep, despite the fact that some of the things we're talking about are a bit dry. Okay, another thing that we must be keeping in mind is that if you file a design application, and if we start making a list, what are all the things that you might claim priority from in the design application that you're filing? It's not only national design applications in other national offices or regional office in the case of EU IPO. You might be claiming priority from a Hague Agreement application, one that somebody filed in the Hague system at WIPO, and that designates at least one state that is not the country that you're in. That could be a priority application for purposes of your country. So for example, somebody files a Hague case that designates, say, France. And now you're going to file in the US within 6 months of when the Hague case was filed. Well, that's a case where a priority claim could be made. And so it matters that the IB could be a depositing office. And indeed, the IB can be a depositing office for designs. The thing is, if you're going to file a design case, you might be claiming priority from a utility patent application. Yeah, it might happen that somebody filed a utility case within the last 6 months, a utility patent application, And it might have drawings that are sufficiently detailed, sufficiently thorough, sufficiently clear, with enough views, with enough disclosure to serve as a priority document for purposes of a design filing, in which case you might be claiming priority from it. If so, then you would be delighted to know that all of these patent offices around the world are depositing offices for utility patent coverage. Argentina, Brazil, for example, ones that were not mentioned earlier. Here we see just many, many more offices that are depositing offices for utility patent coverage. Okay, utility model. Somebody might have filed a utility model application that had drawings that were sufficiently thorough, sufficiently have enough views and so on to serve as a priority document for design purposes. And if so, you could use the DAS system as a way of getting an electronic certified copy of that utility model application from one country to another through the DAS system. And here you have Chile and you have Finland, and GE is what? Georgia. Yeah. So you need to keep these things in mind, because you never know when these things might come up, that you might have an urgent client need that within the last 6 months, somebody filed a utility model case or a patent case, something like that. Finally, here we go. What if somebody filed a PCT application in a receiving office, and what if that was an application that might have been the first application? You know, when you file a PCT, you're not obligated to claim priority from any previous filing. A PCT might be the first thing that ever got filed. And if PCT that got filed might have drawings that are good enough that you could claim priority for purposes of a later design case. If so, then you would care which receiving offices are depositing offices for purposes of DAS. And here's a list of them. These are the receiving offices that are trendy, modern, and up to date. These are the receiving offices that are willing to make PCT applications available electronically to the DAS system. And you look down the list, and who is conspicuously absent? The US receiving office, the ROUS. Now, we all know what ROUS really means. It means rodents of unusual size. But for purposes of today's discussion, it means the receiving office of the USPTO. Now, one of our commenters dropped me a private comment. She said she had learned recently that you can't use DAS for a priority PCT application filed in the US receiving office, and she's exactly right, and that's what this slide is talking about. Wouldn't it be nice if the USPTO would choose to join the club of trendy, modern, and up-to-date receiving offices? Wouldn't it be nice if the US receiving office were to make PCT applications that were filed in the ROUS available to the DAS system? Wouldn't that be nice? Of course it would be. Wouldn't it be nice if a bunch of practitioners perhaps would ask the USPTO to do this good thing? Wouldn't that be something? Well, let's talk about it a little bit later. Rights of priority. Rights of priority. Under US law, most of the comments that we're going to talk about here, are general and would apply with almost any office around the world being the office of first filing, and almost any office around the world being the office of second filing. But many of our attendees are in the US, and so that's why this slide is here, because I'm just talking through one or two of the particular things that work in the US. And one of the things is that if you file a national application in the US, the A that you see here is reminding us of something I mentioned earlier. You can have a right of priority that goes from the Hague case, a previous Hague case that somebody else filed, or that your own client filed, of course, is what we're talking about, but that some other firm probably filed at WIPO, and it designated at least one country that's not the US. The other possibility, another possibility is simply that it was claiming priority from an application filed in a foreign country, or it was claiming priority from a PCT that designated at least one country outside the US. Why? Because the PCT had a bunch of good drawings. Or, as I mentioned earlier, what if somebody filed a Hague case? Okay, we're going to talk about SAO-SIT. how many of you know what SAOSIT means? It means same applicant or successor in title. Google it. Google it later. Those of you who have a computer going right now, plug it into Google right now. Look at your Google search results. You'll be fascinated to see which websites will tell you what SAOSIT means. Same applicant or successor in title. This comes from Paris, Article 4. Article 4 of the Paris Convention, which again, to understand fully, you would want to take the PDF of the Bodenhausen book, print it out, read the whole thing, or at least read all of the Bodenhausen section on Article 4 of Paris. And same applicant or successor in title is so important. Basically, in your office of second filing, who's the applicant? Well, it matters. Why? Because under the Paris Convention, that applicant had darn well better be the same as the applicant in the office of first filing. If they don't match, the priority claim is defective. Well, not necessarily defective, because you might be okay as long as in the office of second filing, you can say with a straight face that the applicant in the office of second filing is the successor in title to the applicant in the office of first filing. But there are many offices around the world, including the UK Patent Office, the Japanese Patent Office, the European Patent Office, that say that the cleanup paperwork, the successor in title paperwork, needs to have been executed chronologically prior to the filing in the office of second filing. This is super important, and I'm going to do a whole webinar about this in the next week or two. For today's webinar, this is just a topic to touch on, just to identify it. The main thing here is make darn sure anytime you are filing in an office of second filing, whether it's design, whether it's patent, make darn sure that you pay attention to who is your applicant in the office of second filing, and go back and look and see who was the applicant in the office of first filing, who was the applicant in the priority case. If they match, well, that's great. If they don't match, have a meeting. People should sit in a room and look at each other and stare at each other and say, what are we going to do about the fact that these applicants don't match? And have that meeting chronologically prior to the filing in the office of second filing. That's what this slide is begging you to pay attention to. I mentioned it earlier. I'm focusing on it now. I'm emphasizing it now. Anytime you file a U.S. application that has a chance of serving as a priority document for later purposes, and this could be for design purposes, this could be for utility patent purposes, anything that might be a priority document later. It might be a U.S. provisional, it might be a U.S. design application, it might be a PCT, which is presenting subject matter not covered in any previous filing. It could be a CIP U.S. application, by which we mean it has at least some subject matter not covered by a previous U.S. filing. No matter what it is, if it's got subject matter in it that didn't have any previous U.S. filing date, there's always the chance that it might serve as a priority document. Make darn sure that you pay attention to who the applicant is, and don't just snooze through it and just let it be the state of nature, which is that the applicant is the inventors or something. Do it with an application data sheet. Oh, now I said earlier, call a meeting and make sure everybody looks at each other and discusses, like, what are we going to do about the fact the applicants don't match? And one of our attendees says, make sure you're sitting 6 feet apart. Good for you. Bless you. This is also a reminder that at least one attendee has not yet been put to sleep by some of this dry subject matter. This is not idle. Same applicant or successor in title is not idle. Some of you saw news articles in January about how one of the companies that's fighting over who gets to own all the patents to CRISPR lost one of the CRISPR patents in Europe. Why? Because somebody snoozed through and didn't get it right on same applicant or successor in title. They filed a PCT where the applicant was so-and-so, and you go back and look at the provisional that they were claiming priority from, and the applicant didn't match. They didn't get SAOSIT right, and they lost a European patent, one of the cornerstone patents to the portfolio of that particular company that hopes that they could have a lock on who owns the CRISPR technology. This is a reminder that you want to focus on same applicant or successor in title. And as I say, I'm going to do a webinar about this in a couple of weeks. We're going to talk about one or two more Article 4 of Paris things, just to be thorough, and then we'll come back to the way that this relates to DAS, but just one or two things. If you read Article 4 of Paris, what you will see is that one of the things it says is that you can't just claim priority from any old previous application in an office of first filing. For example, if you're filing in the US, you can't just pick any old filing in a foreign country. You got to pick the oldest one in the foreign country. And if you're already past your priority period, it's too late. We're going to illustrate this with specific examples. And for some of the people attending, I see some of the names here. There's a person here whose initials are CF, and she knows this down cold. And there are a couple other people attending, a guy whose initials are RN, and he's got this down cold. But I'm just going to emphasize this because maybe not everybody has this completely in mind. Suppose a design application was filed October 1, 2019, almost 6 months ago. And then a second application filed in that same foreign country 6 days later, October 10th, 2019. Can you sit and wait and count 6 months from the second one, and is that when you can file in the US? Can you just say, I'll file from the second one, and that'll be good enough? Well, the answer is yes, you can file. But the priority claim will fail, because you got to file from within 6 months of the earliest one in the foreign country that contains the disclosure that you care about. So if foreign counsel says, we filed 2 applications in France or whatever, you need to pay very close attention to what was the earliest of the 2 filing dates in France, because probably you need to file in the US within 6 months of the earliest one. Or if it were utility coverage, you'd be doing it within 12 months of the earliest one. Now we change our fact pattern slightly. Suppose what was filed in that foreign country on October 4th of 2019 disclosed design A, and then 6 days later, another design application was filed in that foreign country that contained all of the A subject matter and also contained the B, some subject matter that we will call B. Can you now file, say, in the US as an office of second filing, counting 6 months from the second filing, as long as you have the self-control that you only claim the B design? The answer is yes. You can then claim priority from the second of the 2 foreign applications, and it will not be a defect that there was an earlier application, as long as you had the self-control that you did not try to claim any of the A subject matter. Okay. There is also something in the Article 4 of Paris. This is why you have to get the Bodenhausen book. Take the PDF and print it out. It'll only take 600 pages to print it all out, or buy the PDF, buy the bound volume. But read the Article 4 section, and you'll find that there's something called leaving no rights outstanding. If you file on October 4th, 2019, and then 5 days later abandon that application, leaving no rights outstanding, and then a day later file the exact same application again, that restarts your priority clock. And now you can wait 6 months and file, and that will be a valid priority period. So if you do an abandonment leaving no rights outstanding, that starts the 6-month clock all over again, and there is a corresponding restarting of the clock that works for the 12-month clock for utility patent coverage. Mr. Bodenhausen went on about this for several paragraphs in his book, and you've got to get the book, put it on your shelf. Okay. Can you claim a domestic benefit in a design case from a U.S. provisional? The answer is no. The answer is no. Does this mean that if the U.S. provisional had a whole bunch of really good drawings and you now want to try to get a design protection on those drawings, that you can't do it? The answer is no, it is not true that you can't do it. That's a double negative, or maybe it's a triple negative. Why? Because there's a section that says you can convert a provisional to a non-provisional. And indeed, every now and then, people actually find that they need to do this. They will actually convert a US provisional to a non-provisional for the specific reason of then doing a design filing so that they can use the drawings in a provisional. So keep this one in your back pocket as a little bag of tricks thing to do sometime when you have a provisional with really good drawings and the client develops the need to file a design case. Okay, again, here was the legacy approach that we talked through. And now we're going to talk through how you actually use DAS. And the first way we're going to talk about actually using DAS is an outbound direction. The outbound direction here is that you filed in the Office of First Filing, and we will take as our example that the USPTO is where you filed it, and that the USPTO is the Office of First Filing. For our attendees that are in other countries around the world, please understand almost all of this could be talked about in a corresponding way in your own country. But here would just assume for sake of discussion that the Office of First Filing was the USPTO. As long as you use the standard application data sheet as your way of filing your US application, the ADS uses opt-out language, namely that if you use the ADS, it will say that the application is going to be made available to the DAS system. So in general, you will achieve your desired result of your priority application being made available to the DAS system. But it's possible to screw it up. And given that it's possible, people do screw it up. It happens. What are examples of ways that people can screw it up? Well, one way is to not properly sign the ADS. Yeah, to put something between the two virgules. That's the technical word. People say slashes. The geek word is virgule, V-I-R-G-U-L-E. Save that one up. When you're at a cocktail party sometime, use the word virgule in a sentence. People will turn around and look, and they'll say, wow, that person knows the word virgule. I know, none of us are going to get to go to cocktail parties anytime soon, but someday life will be normal again, and we'll get to go to cocktail parties. And when we do, save up the word virgule. It'll be a good one. Anyway, somebody screws up and doesn't sign their ADS properly. They put a wrong character, a smiley face or something between the virgules, or they just forget to sign it. I can think of 2 cases over the years where I just somehow forgot to sign my ADS, and the consequence was, among other things, that that case did not get released to the DAS system. There's also a checkbox in the form that you could check that says, no, I don't want to release my case to the DAS system. And sometimes people are dopey and they check the box. It's a stupid thing to do, I think. Finally, if you fail to include the ADS in your very first EFS web submission, it won't accomplish that goal. This is an important tip here. If you file an application and then only 10 minutes later do another EFS web submission that contains the ADS, that's too late already. That one won't make the release to the DAS system effective. Are there any good reasons not to release an application to DAS? Somebody asks. Well, every now and then I'll run into a practitioner who says, well, what if computer hackers and stuff, what if they somehow find a way to get into DAS or something, or they guess the DAS access code or something like that, and somehow manage to learn your client's secrets by getting them out of the DAS system, and then the client later is going to sue you for malpractice because you shouldn't have released it to the DAS system. Client might say, I was never going to file outside of the US, in which case you should have never released it to DAS, and a hacker could get in there and get a copy of it or whatever. That would be but anyway, maybe somebody would say, but the fact is the DAS system is very secure. The WIPO people designed it intelligently so that if somebody could guess the DAS access code, all that would happen is it would get released to another patent office, who in turn is not going to publish it in a newspaper. It's just going to end up in the European Patent Office or something. My personal way of looking at it is that I just always release every case to DAS. I just don't think of it as a problem. One person here says you ought to get client consent for doing the release to DAS. Well, okay, I will respect a practitioner if they say they should do that. Here is the opt-out language. If somebody wants to check the box in the ADS, they could check this box, and if they did, it would mean that your application that you're filing will not be released to the DAS system. And again, I've made no secret of it. I think in general, you probably don't want to check this box, because in general, you're going to want to make it available to the DAS system. Okay. Assuming that you do successfully make it available to the DAS system, what would happen next? Well, when you're proofreading that filing receipt, we all proofread our filing receipts, right? When you proofread your filing receipt, there will be this sentence that says, yes, I did give permission to access the application via priority document exchange. And so if you had a goal of making your application available to the DAS, part of that goal is going to include keeping an eye on your filing receipt to make sure that you really see the word yes here on your filing receipt. Again, if you have that goal, you would also want to keep an eye on the transaction history in private pair, and you'd want to keep an eye out to make sure that you have this June 3rd line here that says applicants have given acceptable permission, and then the June 6th, which says we at the USPTO actually acted upon the permission, and we actually clicked the button in our system so that it will become available to, they say PDX, and of course what they mean is DAS access by participating foreign offices. So if you had a goal of making it available to DAS, you would you might well want to take a look in the transaction history and make sure these two entries are visible. Outbound DAS from the US. Well, suppose you screwed up. Suppose you screwed up. Why? Because you failed to use an ADS at all, or you failed to sign your ADS, or you checked that box that said I'm opting out, or because you handed in the ADS in your second or subsequent EFS web submission, whatever, one reason or another, or it's a provisional and you used a provisional cover sheet instead of an ADS. How can you fix that problem? Well, you use PTO SB 39, or if you want to, you can make a document of your own devising in your word processor that contains the same language that's in Form SB 39. I don't recommend that. I recommend using the official form, because then the government clerk at the patent office will instantly understand what you mean if you use SB 39. And then in EFS Web, use the correct indexing term, authorization to access application by DAS office. One of our people attending asks, why does USPTO refer to priority document exchange when it really means DAS? Well, it's a vestige. It's like, why do we all have a vermiform appendix attached to our intestine? It's just a vestige of the distant past. There used to not be DAS. It used to be years ago, it was PDX. And so the language is still there. Yeah, one of our attendees says, by the way, maybe part of your standard docketing activity should be that when you file any case that you had a goal that it would become available to the DAS system, maybe you want to docket to check and make sure that those things do turn up in the transaction history. The person suggesting maybe you docket to make sure these two green things do turn up. Yeah, that might be a smart thing to do for somebody who's trying to keep on top of this. Okay. What are your best practices? We can talk about the sort of minimum practices. Let's talk about best practices. I think, in general, any application that has a chance of being a priority document, you should make it available to DAS. Then you should do what is called obtaining a certificate of availability, which I will discuss in some more detail in a moment, and then do what is called setting up of tracking. Tracking is a sort of a tripwire. It means that when a foreign patent office successfully retrieves the application from the DAS system, you'll know that it happened, because you'll get a message from the tracking system. It allows you to really feel like things are under control. Okay, accessing offices for purposes of designs. If you filed a case in the US that might serve as a priority document for purposes of a design filing in a foreign country, which foreign offices are accessing offices? Offices that are willing to receive an electronic certified copy. Well, Australia, Canada, Chile, China, Spain, Georgia, India, Japan, South Korea, Norway, US. Which member of the ID5 is conspicuously absent from this list? EU IPO. gosh darn it, maybe somebody should, suggest to the EU IPO that they should join the DAS system. But anyway, these are the ones that are accessing offices. If you're going to entrust to Chinese counsel responsibility for filing a design application in their office, and they're going to claim priority from a US case that you filed, this tells you you have the opportunity to use DAS. Now, as one of our colleagues pointed out, apparently the Norwegian Patent Office is only just now starting to get it working, but they have a goal of getting it working. One of our attendees asks, so what is this about PDX and DAS? Are the terms interchangeable? Does PDX access mean anything more than DAS access? Yeah, they're essentially, they sort of all mean the same thing in the USPTO. If they say that they have made PDX access available, they really mean PDX and DAS. That's sort of what that means. Outbound access to DAS. The USPTO doesn't actually make it available to DAS until several things happen. First, not until the USPTO has formally stuck its neck out and decided that your case is entitled to a filing date. After all, suppose you filed by express mail. Well, somebody somewhere at the patent office has to look at your filing receipt, your express mail receipt, to see what the date in is from the Postal Service to decide what filing date you're available to, or whatever. I mean, there are procedures at the USPTO by which they work out what filing date you're entitled to. On what date were all of the conditions satisfied for the grant of a filing date. And only when they decide that you're entitled to a specific filing date could they possibly release it to DAS, because only then could they certify it electronically. You'll recall that under Article 4 of Paris, the certification includes a certification as to the date it was filed. So until the USPTO has formally decided what the filing date is, it doesn't make any sense to think of it being released to DAS. Also, the subject matter is not going to get released to DAS until such time as the USPTO has decided that the material can be granted a foreign filing license. Now, for most design subject matter, this usually isn't a problem, but every now and then you'll run into a design case where the grant of a foreign filing license takes some time. And so, but anyway, only when the foreign filing license is granted, that'll be one of the conditions that has to be fulfilled for the USPTO to release the case to the DAS system. Also, the filer has to have given permission, that you did it in the application data sheet or in Form SB 39. The USPTO has to have formally recognized that you gave permission, and the USPTO has to have done the 1 or 2 mouse clicks in their computer system to actually make it so. Clearly, you need to test this independently, and the way you do it is by obtaining what is called a certificate of availability. So, what are your action steps? Anytime you have recently filed a U.S. application, assuming that it's an application that might possibly down the line be a priority document, and one of our attendees says, yeah, set a docket to make sure that you have obtained a certificate of availability. I think that's a sensible thing to do. And set up tracking. But let's back up here. Part of what we're getting at is that for people attending this webinar, maybe you filed a case last month or a month ago or 5 months ago in which you didn't do these things. You didn't make it available to DAS. You got cleanup work to do. That's what I'm getting at. You got cleanup work to do. You got some design case you filed 5 months ago. Get it into DAS now on spec. Why? Because in 2 weeks, the client might say, I want to file in a foreign country claiming priority. You do not want to be scrambling around saying, oh, we better rush, get it into the DAS system. No, clean up the mess now. Take all your cases that you filed within the last 6 months, all your design cases, get them into DAS. Assuming you also have utility cases in your docket, every utility case, every patent case that you filed within the last 12 months that is not already in DAS, get it into the DAS system. It's an action step. This may mean that you have to file Form SB 39 one by one in a bunch of your old pending cases. And then for each such case, get a certificate of availability and set up the so-called tracking. Then, for every case going forward, part of what this webinar is urging you to do is for each case going forward, When you file a new case, get it into DAS, get a certificate of availability, set up tracking. One of our attendees says, well, fine, okay, so now we're setting and clearing a whole bunch of dockets for all this DAS stuff. Am I really any better off than under the old legacy procedure? Yes, of course. We're only talking setting like 2-3 dockets here. Under legacy practice, 12 dockets. Not only that, under legacy practice, there were so many things that could go wrong. A DHL package that got lost as it was passing over the Atlantic Ocean, a postal service package that got lost on its way to Alexandria, and so on. Whereas here, just the range of things that could go wrong was not as big a universe of things that could go wrong. You want to be using DAS, and you want to be trendy, modern, and up to date. Come on, admit it. Okay. Here is a certificate of availability. This is an actual one from a real case. This is from a design case. And you want one of these, I will put it to you. You want one for every case in your docket, every design case, every utility patent case. If the USPTO would join for purposes of ROUS, the receiving office, you'd want one for every US receiving office case that you have filed. But basically here, what we're talking about is you want a so-called certificate of availability, and it will show how long it's been available. This one has been available since February of 2018. Okay, and then it shows which offices are capable of retrieving it. That is to say, which offices are accessing offices. Yeah. Tracking. I keep talking about tracking over and over and over again. Let's actually look at it. So if you go into the DAS system, and hopefully almost all of you have seen a screen that looks a little bit like this because you did the DAS quiz, right? You did the DAS quiz and you have a workbench, you know, because you got a WIPO user ID and password, and you logged in and you went to your DAS workbench, and it looked a little bit like this with rows and columns. And here's part of my workbench. And here you can see some of my design cases that are in my workbench. And down in the center, you can see where it says add tracking, and this is what we're talking about. You could click on add tracking, and this is going to permit you to add something to your workbench. Also on this page, you will see a column called last accessed, and this means that the tripwire got tripped. And this is a real life one here. There's a Chinese priority application where the tripwire got tripped on January 3rd of 2020. And it means that the US Patent Office, I mean, you can't tell that it was US here, but you know that some office somewhere in the world did retrieve an electronic certified copy on January 3rd, 2020 of this Chinese design case, a Chinese design case that was filed on July 3rd of 2019. And so this is a real page from my workbench. Also, in your DAS workbench, you have a page called notifications, and this allows you to see tripwire things that happened. And this allows you to see, for example, what's an example? Oh, down toward the bottom, accessing office IB successfully retrieves this document, and this tells me that on March 30th, which is just yesterday, in the morning, WIPO, the International Bureau, successfully retrieved electronic certified copies of 2 provisional cases, 62/something and 62/something else, from the DAS system. That was for a PCT case that I filed. And that's the tripwire. That tells me that the IB really did retrieve those 2 electronic certified copies. And then you see a bunch of 62s in the middle of the page, and these are people who did the DAS quiz yesterday. Some of you may recognize your own email addresses there. Somebody at MTIP Law, a couple of different people at MTIP Law did the DAS quiz yesterday, and I got little tripwire notifications. Finally, at the top, there's a US design case where I set up tracking for the first time in a design case that our office filed a while back, and I set up tracking just early this morning, actually, in one of our design cases. One of our commenters says, when I go to add tracking, what is the access code for a PCT where the RO was the IB? The answer is you have to let me take the question that just came in and repeat it back to the group. So one of our people is asking if I filed a PCT in the ROIB and I would like to take that PCT application and load it into the DAS system for tracking purposes, how do I get the access code? The answer is in two parts. First, when you filed your PCT in the first place, there's a place in the request form where if you choose to do it, and it's a smart thing to do, you can check a box that says, please give me an access code, and then they'll just send you an access code without your having to ask. And then you'll receive form PCT RO132, or maybe, yeah, RO132, and it will contain a DAS access code. Or if you didn't do it when you filed your PCT in the first place, if you didn't do it in the request, you can go into ePCT and there's an action that says request that my case be made available to the DAS system. It's an ePCT action, and then later they will send you form RO132 letting you know your DAS access code. So that's how you would learn your DAS access code for an ROIB case. Is the DAS process required for PCT applications? Well, it depends. If you file in the ROIB, which is where I almost always file almost all of my PCT cases, you need to somehow get a certified copy into the ROIB from the place where you filed your priority case, which in my case is almost always the USPTO, and DAS is perfect for that. So I make sure that all my provisionals, for example, are in DAS, and then I use DAS as my way of getting the certified copies to the ROIB. Yeah. Okay, anyway, notifications. Retrieval history. So 2 slides ago, here we had last accessed, and this was where a design case filed in China in July of 2019 had been retrieved by some office somewhere in January of 2020. And then if I clicked on that little arrow, it would pop up a detail page telling me exactly what happened. And this tells me that on January 3rd of 2020, which office retrieved it? Well, it was the US. The US Patent Office retrieved it successfully, retrieved this Chinese priority application, this design case from China. And this tripwire is very helpful because it means that later if the USPTO were to say, oh, we couldn't retrieve it, oh, there was a problem, I can look here and I can see, no, they did retrieve it. And one of our people asks, has anyone been successful in getting a US design priority doc accessed in China through DAS? I did everything by the book, but Foreign Counsel says the China IP office was not able to access DAS for design applications, even though it is an accessing office for DAS. I believe we have in our office. I believe we have done design filings in China. One of the important things is take a certificate of availability from the DAS system and provide it to Chinese counsel. They can then show that certificate of availability to the Chinese Patent Office, and that can be an important part of helping the Chinese Patent Office understand that they should be able to retrieve it. Yeah. You can also make an inquiry to the DAS help desk at WIPO. It's pct@wipo.int. They can help with that too sometimes. Okay, now we're going to talk about the other direction, which is inbound to the United States. And again, for those of us attending in other countries outside the US, many of these inbound things would apply equally in whatever country you're in, but I'm using the US as the example. So if what you're getting ready to do is file in the US as an office of second filing, this means the priority document was filed somewhere outside of the US. And if the place it was filed was any of the places listed here, Australia, Canada, Chile, China, Spain, Georgia, India, Japan, Korea, Norway, then the Foreign Counsel might give you a certificate of availability in their instruction package. And if they do, by the way, this tells you that Foreign Counsel are trendy, modern, and up to date. Yeah, if they send you a certificate of availability, they are trendy, modern, and up to date. And by the way, that tells you maybe that's the kind of firm you want to send your work to in the future because they're trendy, modern, and up to date. And if they tell you the DAS access code without your having to ask, they're probably trendy, modern, and up to date. Now, you would still independently want to set up tracking in the DAS system yourself, no matter what. And then that tells you when the USPTO does electronically retrieve the certified copy, the electronic certified copy, you'll know about it. You, the US counsel, are still going to have to dock it and make sure that the US examiner checks box 4 or box 12 to acknowledge that the certified copy is there. And of course, you're probably going to want to dock it to watch and make sure that the tripwire gets tripped, namely that DAS tells you that the USPTO retrieved the electronic certified document, electronic certified copy. Some of our attendees asked a couple of questions. If the USPTO doesn't retrieve the electronic certified copy, do you waive the certificate of availability at them? I do. Sometimes I will file the certificate of availability in EFS Web as a way of rubbing their nose in the fact that they should be able to retrieve it, that they ought not to claim to be incapable of retrieving it, because here's the certificate of availability. In what document are boxes 4 and 12 found? Thank you, that's a good question. Box 4 is found in the standard office action form, form PTOL 307 or something like that. That's the form where the examiner says that it's either a final office action or non-final, box 4. Or if you get a notice of allowance, that's where the box 12 is that you hope is checked. That's where those boxes are. Is there a way to set up tracking in DAS if you do not yet have the access code? No, you won't be able to. If you don't have the DAS access code, you won't be able to set up the tracking. So if foreign counsel have not yet given you the DAS access code, that's a holdup. That's making it so that you can't really move forward the way you would like. What you clearly want to do is work to the extent you can with foreign counsel who are on top of these things and who get you your DAS access code promptly in the process. Is there any benefit to tracking an application that is made as second filing? Well, I like to do it just on general principles. One reason is the application filed in the Office of Second Filing, if there's anything in it that might possibly count as new matter, well, then it might become a priority document for yet another filing. USPTO did not acknowledge a request to retrieve. Oh, okay. So this person is saying, I asked the USPTO to retrieve it electronically. They didn't do it. Should I nonetheless hand in a physical certified copy or what? Well, there's this whole procedure called interim copies, and you should read about it. It's in 37 CFR 1.55. You shouldn't have to do interim copies. USPTO should in fact retrieve the certified copy electronically as soon as you ask them to do it. They actually age it. They wait and don't retrieve it until the examiner is about to pick up the case, which I think is terrible. Talking a little bit more about the inbound process to the USPTO, assuming it was a design case, you want to make sure that the priority information is accurate. Copying and pasting into the ADS, you'd hate to put into the ADS a wrong digit in the application number or an incorrect character in the DAS access code or something. Why? Because it's your fault. If there's something wrong with the characters in that ADS, if there's something wrong with it, it's your fault, and then you could end up with a defective priority claim. Suppose somebody files a Hague case and they designate the US. This means it's going to have a series code of 35, by the way, as you all know. What happens all too often is that US design patents issue from those Hague cases with defective priority claims. Why? Because somehow it never quite happens that a certified copy finds its way into that US file. DAS can save the day for those cases. And for the people attending today's webinar who are in countries outside the US, make darn sure that in form DM1, the Hague form, that you put in the DAS access code, assuming that your priority filing was in one of the countries that is a depositing office for DAS. Otherwise, have U.S. counsel use Form SB38 to provide the DAS access code. Otherwise, a physical certified copy is going to have to be provided to the USPTO. Make darn sure that the U.S. examiner checks box 4 or box 12 in that 35 series U.S. case. It is tantamount to malpractice to fail to keep on top of that. Again, if you have a Hague case that designates the U.S., a 35 series case, and if you are U.S. counsel responsible for that case, make darn sure that Form DM1 had the DAS access code in it, or make sure that Form SB38 gets filed to provide it separately. TYFNIL, 10 years from now in litigation, you should Google it. Google TYFNIL. I promise you, at litigation time, the adversary would notice if somebody screwed this up. If the certified copy did not find its way into the case prior to the issuance, it would get noticed at litigation time. There are offices that care about this sort of thing. And for outbound work that is going out of the U.S., you filed your U.S. counsel, you filed a Hague case, and you designated Japan. The Japanese Patent Office is one of the offices that cares whether a certified copy did or did not reach the Japanese Patent Office as part of the Hague process. Here's a quote from the Japanese Patent Office that if you file a Hague case and designate Japan, and if you provide a DAS access code in the form DM1, the Japanese Patent Office will electronically receive the party document through the DAS system as of January 1 of 2020. That is to say, if the international registration date of the design case is on or after January 1, 2020, the Japanese Patent Office will retrieve the electronic certified copy through the DAS system. But this only works if the DAS access code was in Form DM1, so the filer of the Hague case needs to make sure that they did that in Form DM1. Consequences of failure. Consequences of failure include failing to even present the priority claim prior to issuance, or failing to get the certified copy into the file prior to issuance. Either of those slip-ups will mean that the priority claim has not been perfected, and that will be a problem at litigation time. And again, box 4 in the office action form or box 12 in the notice of allowance will hopefully have been checked by the examiner, at which point you could relax. Okay, 4 and 16, I mentioned this earlier, and there is no 4 and 16 limit for design, but those of us who also do utility patent practice, we need to burn that into our minds for utility cases. You need to have presented your priority claim chronologically before the 4 and 16 limit, that is to say, before 4 months have elapsed from when the Office of Second Filing application was filed, and within 16 months of when the priority case was filed, whichever is later, and the certified copy has to have been provided within the 4 and 16 time limit. With design cases, there is no 4 and 16 limit, but both of those events needs to have been fulfilled chronologically before the issuance of the design case. But that's the bare minimum, and best practice is you'd want to get everything done so that box 4 or box 12 were checked. You want to get it all done early enough that box 4 or 12 were checked, so that you have a nice clear paper record that you perfected the priority claim. When something goes wrong with getting a certified copy into the U.S. Patent Office, what is the list of all the things that could have gone wrong? Well, a U.S. practitioner could have gotten a digit wrong in the ADS digit of the application number or the Form SB38. The U.S. practitioner could have gotten the country code wrong. They could have typed GE when they were trying to say Germany, but of course Germany is DE. The U.S. practitioner could have gotten the filing date wrong. It was May 4th, and they put down 5/4, which means April 5th. The U.S. practitioner could have gotten the DAS access code wrong. Of course, you should be copying and pasting from a trusted source, not typing with your fingers. Or the office where the priority application was filed, the Office of First Filing might have gotten something wrong. Suppose they said they made it available to DAS, but somehow they slipped up and didn't actually make it available to DAS through some inadvertence, failure to click the right mouse click somewhere. When they reported what they said the DAS access code was, did they get a character wrong in the DAS access code? Or did the USPTO somehow slip something up? Did they in fact successfully retrieve it, but didn't in fact get it into IFW? Or did they say that they couldn't get it from DAS when in fact it was something they could have gotten from DAS? Or did the foreign practitioner somehow slip up? Did they got a digit wrong when they told you what the application number was? Or did they get the date wrong when they told you the filing date, or did they get a character wrong in the access code, the DAS access code? These are all things that could have gone wrong, huh? The thing about DAS is that you can be completely in control. You can troubleshoot every bit of this completely from the top to the bottom. How? By getting a certificate of availability. Once you have the certificate of availability, once you set up the tracking, you are in complete control. You know that you must have gotten the application number right, or you would never have been able to get that certificate of availability. You must have gotten the filing date right. You must have gotten the access code right. If you managed to set up the tracking, you must have gotten all those things right. Once you set up the tracking, if the USPTO says they didn't retrieve it, but you get a tracking notification that they did receive it, you're on top of things. You know what really happened. So use the workbench, use the tracking, use the certificates of availability. To do it, you need to log into DAS. Almost all of you already did this because you did the DAS quiz. But for the handful of you who maybe didn't do it, you need to get a user ID and password from WIPO. It is super easy to do. You go to the WIPO website, you do a couple of mouse clicks. It's super easy. Then you click on PCT, then you click on DAS, you click on Access the WIPO Digital Access Service. It's easy. It's easy. Most of you, I mentioned series codes before. When you get somebody new in your office and they're just being exposed to this for the first time, remind the new person that ordinary US design cases have a series code of 29 and that the Hague cases have a series code of 35. And I'm waiting for somebody to slap the buzzer here. The 29 series code is almost used up. 29/9 is what we're up to, 29/959 or something. So before the end of the year 2020, the 29 series code is going to be used up and it'll be 30. 30 will be the series code for designs. Okay, I mentioned Form DM1 several times. Here is the relevant part of Form DM1. Anybody who's filing a Hague case, when you get down to box 13 of Form DM1 and you're filing a Hague case, when you're putting in that you're making a priority claim, you want to fill in the DAS access code if you can. Of course, you can't do it if the Office of First Filing was an office that isn't a member of the club, doesn't belong to the club, isn't a depositing office in the DAS system. But assuming that the Office of First Filing is a depositing office in the DAS system, you want to make darn sure you get the access code in here. The USPTO is a depositing office in the DAS system, so you'll put this in. But you might be claiming priority from a U.S. utility case. Why? Because the drawings are really good, and within 6 months of the U.S. utility case being filed, you're doing a Hague case. Well, then you'll be filling in a U.S. utility case and an access code. By the way, what is the access code? It's the same as the confirmation number in private pair, right? We all know that. Anyway, Form DM1. Now, this form is shown as a fillable PDF. This is only for convenience of showing it in a presentation slide. If you are trendy, modern, and up to date, you will never use this form. Of course not. Why? Because you're going to use the online form. The online form where you fill in the blanks in a web-based form because it performs validations. It saves you from malpractice. You never want to use the fillable PDF. Okay. Or if you're going to file in the US as an Office of Indirect Filing, well, then you have to use the PDF. But if you're going to do that, do the online form, the web-based form, to get the benefit of the validations, even if you don't click submit in the web-based form. Use that for the validations. Anyway, Form AIA 14, this is the application data sheet form for filing a US application. Any US application that has a chance of later being a priority document. Maybe it's a US provisional, maybe it's a US ordinary utility patent case, maybe it's a US design case. In general, if there's a chance that it might later serve as a priority document, you always want to use Form AIA 14 so that it will be released to the DAS system. And if you're going to file a US case that's going to claim priority to some foreign case, you would use this section if the foreign application was filed in a country that is a depositing office, and you'd put in the access code from that foreign country. Now, I mentioned earlier, wouldn't it be nice if somebody somewhere would ask the Commissioner for Patents to do something better about DAS? And in fact, a letter got sent on February 22nd of 2020 to Commissioner Hirschfeld, the Commissioner for Patents. 31 patent practitioners sent a letter to Commissioner Hirschfeld, and the letter asked Commissioner Hirschfeld to please make it so that the ROUS would become a depositing office for purposes of DAS. The letter also asked Commissioner Hirschfeld to reformat Form SB 38. Why? Because the little box where you fill in the access code was so small that you couldn't read it later. And finally, it asked that when the USPTO is asked to retrieve an electronic certified copy, would it please do it right away rather than actively aging it until later when the case hits the desk of an examiner. And it will be interesting to see if the Commissioner for Patents does those things. Here is what Form SB 38 looked like up until 2 weeks ago. And look how tiny that box was for the access code where it says E94A, and I know what it says because I filled in that form, but it's a very small little box. And because of that letter, Commissioner Hirschfeld already made somebody redesign the form, and the box is bigger now. This form was reformatted in the last week of February 2020 to make that box bigger, and now it's more readable. So the letter actually worked as to that. But we had two other asks that relate to DAS. We asked that the ROUS please become a depositing office, and that when the USPTO is asked to retrieve an electronic certified copy, would they please do it right away rather than sitting on it? And we'll see if that works out. Now, I mentioned that the European Union Intellectual Property Office has not yet joined DAS. Well, there's a letter that's going to get written, that's going to get sent tomorrow to the executive director asking that the European Union Intellectual Property Office please become a participating office in DAS, and that letter is going to get sent tomorrow. Right now, it has 62 signers. I'm asking all of you who are attending, please consider signing that letter. Go to my blog and you will see where you can sign that letter. Add your signature to that letter. The opportunity to sign will end this evening. Later today, March 31st. Please consider signing that letter, and tomorrow is when the letter will be sent to the executive director. What's the next webinar? Starting tomorrow and Thursday, there will be a 2-day series of 2 webinars learning how to be paperless with the Patent Cooperation Treaty. Why? Because just yesterday, WIPO announced they're going to stop mailing out paper in PCT. Why? Because of the COVID problem. They're all working from home now in Switzerland, and they can't mail out paper anymore. There's nobody to, print stuff and stick it in envelopes, and nobody wants to lick envelopes and drop them in mailboxes. And so they, yesterday, as an extreme measure, decided to stop sending out paper. The problem, of course, is there are a lot of PCT filers who were not trendy, modern, and up to date. PCT filers who check the box that says, I want paper communications. And so WIPO is now in this very tough position of having a lot of PCT filers who aren't going to get their stuff in the mail. And I'm going to do 2 webinars tomorrow and the next day explaining to people how in the world to switch over to receiving their stuff electronically. So this is a webinar tomorrow and a continuation of the webinar on Thursday. If you know anybody who is not trendy, modern, and up to date, anybody who's a PCT filer that you think might not be completely up to date on this, beat them up, tell them they have to attend these webinars, which are free of charge, and that's tomorrow and the next day. So just tell everybody you know who files PCT. We have questions that came in. Somebody says, Das ist sehr gut. Yes, that's right, it is sehr gut. Can you resend the link to the letter for signature? No, I can't resend the link, but go to my blog, for gosh sakes. Go to the search box and plug in Commissioner for Patents. You'll get to the right page. You can sign, I promise you. Do you need a full address along with the signature? No, you just put in your name if you want. Can you send links to join the webinar? No, go to my blog, blog.opidol.com, and just look, it's the first or second article. I'm going to do some webinars in the next couple of weeks. One of them is on Get Patents Fast, ways to get patents fast, Patent Prosecution Highway, Track 1, making a case special because your inventor is 65 years old or older. Another webinar on what you should do so that you don't end up like the owner of the CRISPR patent who lost their patent because they screwed up same applicant or successor in title. A dedicated webinar just on how to do best practices for docketing of PCT, a webinar on how to select your PCT searching authority, a webinar on how to select your PCT receiving office, a webinar on how to make smart use of PCT declarations, a webinar on how to choose between using national phase or bypass continuation as your way of getting a US patent from a PCT, a webinar about how to handle sequence listings in your PCT filings. Somebody asked, what's another way of getting an access code for a foreign party application if you cannot reach the foreign associate? It's very tough. In general, you have to contact whoever filed that foreign application in the first place. It's very hard to get it any other way. With that, I will say you should join the Designs Listserv. Just go to Google and plug in Designs Listserv or Opidal Designs Listserv. You must join the Designs Listserv. It's an email discussion group of about 600 design practitioners, and you can just lurk. You don't have to do anything. You don't have to post. But if you lurk, you will see people will post questions. Other people will answer them. If you do have a question, you could post it. People are very generous. Even in the evening or on a weekend, people might help you with a question or a problem that you might have. You should join the Designs Listserv. You should subscribe to my blog. By the way, I promise you, your email address will not be sold to spammers or anything like that. Yes, you'll get emails from me. That's the price you have to pay, but it won't go to spammers and things. But join the Designs Listserv. You could always unsubscribe later if you decide it's not for you. You might as well just give up, subscribe to my blog. You might as well do it. You could always unsubscribe later if you felt like you had were getting no benefit from it. And if you want to learn about the timing and availability of the upcoming webinars, subscribe to my blog and you'll hear about them. If you want help with these various DAS-related things, pdx@uspto.gov is the email for help with DAS. The EBC can also help at WIPO, pct.eservices, or you can call the PCT help desk and they will help you. The people at WIPO are extremely helpful. They are very, very, very helpful. And finally, later you'll get an evaluation form for this webinar. Please be sure to fill out the evaluation form. With that, thank you very much, and we have completed our webinar. Good day now.